incorrect or it's been misquoted. So what you see here is that the PCA Secretary General concluded that, quote, concurrent service as an arbitrator and as a counsel in an unrelated matter in which the same expert has been engaged does not automatically result in a conflict of interest warranting disqualification. Objective evidence would be required that makes it manifest that the appearance of the same expert in the two proceedings may, in the specific case, affect the arbitrator's decision-making. And then the PCA Secretary General went on to say that Pakistan, quote, had not shown that the relationship between Dr. Alexandrov and the expert goes beyond a normal working relationship as is common between counsel and valuation experts involved in international arbitrations. He goes on to say, in the alternative, even if I were to consider that such prior relationships between an arbitrator and an institution may in principle give rise to an appearance of bias, the absence of express rules or arbitral precedent on this issue leads me to conclude that such an appearance is not in any event manifest. Now, here we can glean a few things from this. First, you need objective evidence that the relationship goes beyond a normal working relationship. That's completely lacking here. Second, even if it's predicated on this alternative language, there are no rules or precedent that can be interpreted in that matter. Now, the absence of rules that govern this is uncontested. There's no ICSID rule that requires or that talks about this type of relationship. And the ICSID chairman of the Administrative Council made clear that it's only the ICSID convention and rules that apply in this circumstance. Guatemala has argued, well, what's different now is there's arbitral precedent because we have ICSID. That can't mean what they say. Because if the reason why this disqualification could not succeed was because in the alternative, first, there was no objective evidence, but also there's no rules against this and there's no precedent. If that's correct, it's just correct for the ICSID committee as well. When the ICSID committee was deciding it, they too should not have ruled that way. There was similarly no rules and no arbitral precedent. So they're acting contrary to this, in other words, right? At odds with this. They're creating precedent, but just like it would have been wrong to disqualify here, given the lack of rules and lack of precedent, it was wrong, we contend, in ICSID for that committee to do it. And certainly, just because then ICSID decides it, that cannot mean that then it becomes automatically disqualifying, especially for a case where an award had already been issued, which, as I showed in the timeline, was the case in our situation in TECO.
Ms. Menaka,
yes.
Sorry, do we know if Bear Creek was a past arbitration or concurrent arbitration? Was it running parallel to TCC versus Pakistan?
I don't want to misspeak, so I need to double check.
Okay.
I don't recall
Just if you can
right
check
off the
both
top
parties.
of my head. Okay. So then the unchallenged members, the second decision we have is with respect to after the PCA Secretary General issues his recommendation, the unchallenged members of the TCC tribunal agree with the PCA Secretary General, and they dismiss the challenge. They find that the circumstances do not exhibit a manifest lack of independence or impartiality. Then third, later, after the second disqualification application is made, that goes to the chairman of ICSID's Administrative Council, and he also dismisses it. Now, he says here that a few important things about this, I think, is first, if you look at the right side of the page and paragraph, and this is slide 55, paragraph 69, and this is a quotation from the chairman's decision. He says, quote, a third party undertaking a reasonable evaluation of the factual framework would not conclude that Dr. Alexandrov manifestly evidences an appearance of a lack of independence and impartiality. And important to note there, they are applying an objective standard, of course, a third party that is looking at this. Second thing to note is, as I noted before, Guatemala makes much of the fact that Dr. Alexandrov resigned in the Soles case against Spain. That was also raised here. And what did the ICSID chairman say about that? He said, as far as the reports that the unchallenged members were equally divided, any arguments made on that are quote unquote highly speculative. And this additional information, this new fact of the Soles resignation, cannot be construed as proof of Dr. Alexandrov's alleged unreliability to exercise independent judgment in this case. So then we come to Misen versus Ukraine, where in this recent decision from April of this year, the chairman of ICSID's Administrative Council confirmed that, again, acting as arbitrator and counsel with a party's expert without more is not disqualifying. And again, the chairman states that a third party undertaking a reasonable evaluation of the facts would not conclude that there is a manifest lack of independence or impartiality, and they dismiss the challenge. Now, ICSID, in its decision, what it did, in addition to imposing an actual knowledge standard, while stating the rule that constructive knowledge was sufficient, it also improperly imposed a new high bar on arbitrators who double hat or who act as both counsel and arbitrators. And you can see this in their decision. They talk about the increased risks and possibilities of conflicts when you have arbitrators who also act as counsel. And they say, therefore, they must set the bar high. Now, of course, the committee is not making any sort of determination as to whether double hatting should be permissible or not permissible. That's not its mandate. But one should keep in mind that what Guatemala is essentially asking, if it were granted, would essentially amount to a prohibition on the practice. And that's for a number of reasons. First, if you look at ICSID's working paper from 2021 last year, they found that in 58% of the cases, there were double hatters, so to speak. And while Guatemala says that's not at issue, if here, where there's not been shown any overlap in issues between the cases that Dr. Alexandrov and Mr. Kazmarek were working on as counsel and expert respectively, and our case, and there's no evidence of actual bias, and there's no evidence that Dr. Alexandrov had any sort of undue impact. In fact, he dissented on a major portion of the case. And taking that into account and the public nature of the information, the disclosures that were made, again, the lack of overlap of issues, if that's still sufficient to annul, it is an indictment of double hatting, because it's difficult to think of a circumstance where that would be okay. And you see this in both the criticisms of the ICSID award and also the prevailing circumstances in the practice today. So on slide 58, you see that the ICSID award has been widely criticized for a number of different reasons. So if you look at Gary Bourne's treatise, he states that the ICSID decision is, quote, unrepresentative and clearly erroneous. In other articles, others have also interpreted the ICSID decision as essentially drawing a line in the sand against double hatting, and where the ICSID rules do not prohibit that. And they also indicate that it would make the system unworkable, because the fact is that when you have an arbitrator who works as an arbitrator in many, many cases and is also active counsel, you are bound to come across the same experts in both your counsel practice and as arbitrator. given the small community of those experts. Now, critically, in the Misen versus Ukraine decision, the ICSID administrative chairman rejected Iser's reasoning. And if you look at this, he does not, perhaps maybe he was being a little diplomatic and does not state, I reject Iser's reasoning, but that is what he is doing. So if you take a look at slide 59, look at the respondent's argument on the left-hand side. The respondent suggests, quote, as a lead counsel in the matter, Dr. Alexandrov is in all probability working closely with the experts and maintaining a professional relationship with them. The respondent relies on the decision of the ad hoc committee in Iser, which held that, quote, damages experts work closely with counsel in the preparation of a case. They do not and cannot possibly maintain between them the kind of professional distance which is required to be maintained between a party, its counsel, and its experts in a case on the one hand, and the members of the tribunal hearing that case on the other, end quote. Then you look at the decision of the chairman, and he says, quote, the respondent's position rests on the presumption that damages experts work closely with counsel and therefore cannot maintain, quote, the required professional distance which is required to be maintained between a party, its counsel, its experts in a case on the one hand, and members of the tribunal hearing the case on the other. That's a quote from Iser. He goes on to say, while the respondent asserts that, quote, it is likely that his lead counsel, Dr. Alexandrov, will be working closely with the experts, maintaining a professional relationship with them, it does not argue that a relationship of dependence exists between Dr. Alexandrov and the experts that could encroach on Alexandrov's independence and impartiality. Then he goes on to say that the cases do not concern similar facts or similar legal issues, and there's not been shown that the relationship could otherwise cause prejudgment. So based on this evidence, he dismisses the disqualification request. So he is, I said implicitly, but really expressly disagreeing with the Iser Annulment Committee's decision. And this is the chairman of ICSID's Administrative Council. Now here, Guatemala also doesn't argue, much less prove, that there is a relationship of dependence between Dr. Alexandrov and Mr. Kaczmarek, nor could it. There's no financial dependence between them. If anything, they're financially dependent upon the same client. They're not financially dependent upon one another. Nor does Guatemala argue that the cases concern similar facts or legal issues. They've made no attempt to make such a showing. Nor does Guatemala show that the relationship could otherwise have caused any prejudgment on the legal issues. So absent any of those factors, all that's left is the fact that they work together. And if you look at slide 60, you will see in Misen, again, the ICSID chairman, he recognized that quantum experts specialized in the field are few in number, and some interaction between arbitrators and experts is thus to be accepted. Nigel Blackaby, Guatemala's counsel throughout these proceedings until this annulment proceeding, also recognized that there's a body of professional testifying experts who regularly appear before tribunals hearing investment treaty cases. And arbitrator Jones has recognized that these repeat experts are actually a good thing. And as he asked with his question earlier, that is because, as he alluded to with his question, that's because the experts owe a duty to the tribunal. So they are independent experts. Yes, they are retained by a party, but they are independent experts. And when they give their oath in an ICSID arbitration before testifying, they testify that they avow that they are going to testify in accordance with their sincere belief, right? They are not advocates. And that is advantageous then to have repeat experts, because it does, they gain a reputation and they have an incentive not to take extreme positions and not to act as advocates. So Mr. Kaczmarek's retention by clients in cases where Dr. Alexandrov was counsel is entirely unsurprising. And you can see in slide 61 that in this survey, Mr. Kaczmarek was actually the most commonly retained damages expert in the world in investment arbitration cases. Given that, it would be surprising if someone was very active in the field and had not worked on a case with him. So going to slide 62, again, Guatemala's case, when you look at it, it's based on pure speculation. They say, for instance, in their memorial that Dr. Alexandrov, was working, quote unquote, side by side, cooperating, no doubt, by means of face-to-face meetings and telephone communications in undisclosed times and of undisclosed durations, and that it, quote, could not be discounted. Again, I quoted this before, that Dr. Alexandrov and Mr. Kaczmarek have already established a friendship. In their application for annulment, in paragraph 39, they talk about a alleged longstanding relationship, and they say that they coordinated directly. They have no evidence of that. In fact, the evidence that is on the record refutes that, because in cases where Dr. Alexandrov has acted as counsel in these challenges that have been brought, it turns out that he was not working closely with the damages experts. His partners were. So as my colleague mentioned before, the transcripts for some of these cases are on the record, particularly in Spence versus Costa Rica. And there you can see that Mrs. McCandless handled the examination of the damages experts, not Dr. Alexandrov. And in the Meeson versus Ukraine decision, where again, Dr. Alexandrov was given the opportunity to supply explanations, he explained to the chairman of the administrative council that as lead counsel, he has overall responsibility for the case, but he's not directly responsible for the subject matter of the expert's testimony, which again was quantum. So it's purely, not only pure speculation, but it's actually goes against the only objective evidence that we have on the record in this case to assume that he was closely coordinating with Mr. Kaczmarek in our case. Then if you look further, what other evidence do we have on the record? Guatemala says here, and this is at slide 63, that Mr. Kaczmarek and Dr. Alexandrov were, quote unquote, tied to the hip. They were, quote unquote, an inseparable duo. It's like an inseparable quadruplet or sextuplet is what it is. It's not an inseparable duo, because in each of these cases, he is apparently alleged to have this special relationship that goes beyond a professional relationship with all of these other damages experts. And that's because there is a small handful and you come across many of them. So in TCC versus Pakistan, he was alleged to have a long-standing continuing work relationship with the Brattle Group, Mr. Graham Davis. In Iser versus Spain, it was again the Brattle Group, but it was with Carlos Lapuerta that he was alleged to have a close working relationship. In Soles versus Spain, again, Carlos Lapuerta of the Brattle Group, that he spent allegedly, quote unquote, countless hours working with him. In Meisen versus Ukraine, it's yet a different firm. It's Compass Lexicon and two different experts with which he is alleged to have worked closely. These are normal working relationships. There's nothing special about them. Certainly, it does not show that Mr. Kaczmarek and Dr. Alexandrov were somehow tied to the hip, as Guatemala alleges. Further objective evidence undermining this allegation is found on slide 64, because we know here, while Guatemala surmises or speculates and says oftentimes the law firm, the first thing they do is hire the damages experts. Sometimes the damages experts come to the pitches to pitch for the case, to get the case. There's no evidence of that. What evidence is on the record is that Costa Rica put out a tender not only for international counsel, but a separate tender for quantum experts. So Costa Rica hired Mr. Kaczmarek directly in two cases, actually three cases, because two of them were consolidated. So these are three of the 7 cases Guatemala relies on. We also know that Peru hired Mr. Kaczmarek directly, not necessarily through counsel, because Mr. Kaczmarek appears as a damages expert in cases for Peru when Sidley Austin was not representing Peru. So in the Gramercy versus Peru and Convial versus Peru cases, International Council for Peru was not Sidley Austin or Dr. Alexandrov, but Mr. Kazmarek was still Peru's damages expert. This shows that he has a relationship with the clients as opposed to necessarily with the law firms. He's being hired directly by Costa Rica, directly by Peru. Mr. Kazmarek and Dr. Alexandrov also have been retained by opposing parties. And two examples, Duke Energy versus Peru and Lone Star Funds versus Korea. In both of those cases, they are on opposite sides, and I would draw the tribunal's attention to paragraph 39 of the application for annulment, where Guatemala states erroneously that Dr. Alexandrov and Mr. Kazmarek have a long-standing relationship, quote, always defending the same disputed interests. Clearly not true. They're not always defending the same interests. So as the St. Joban versus Venezuela tribunal indicated or held, absent any specific facts which indicate that the arbitrator is not able to distance himself in a professional manner, the arbitrator has the assumption in his favor that he is a legal professional with the ability to keep a professional distance. And Dr. Alexandrov is entitled to that assumption. Now, we heard a lot about the Liricon decision. That was the case that was pending during the pendency of TECO's decision. And in the reply, it is mentioned all over the place. What Guatemala fails to say is the Lone Star case was also pending during the TECO resubmission case. So if one looks at Liricon versus Peru, a claim for $95 million, and Dr. Alexandrov and Mr. Kazmarek are engaged by Peru, defending against that $95 million claim during the TECO resubmission proceeding. Also during the TECO resubmission proceeding, Dr. Alexandrov is working for Lone Star Funds, bringing a $4.5 billion claim against Korea. Mr. Kazmarek is the expert that is retained by Korea to defeat that claim. That is pending during the resubmission claim. You hear a lot, you see the timelines where Guatemala has shown where briefs or expert reports were submitted in Liricon and compared that to our case. Well, here, October 2020, there's a hearing, a 2-day hearing in Lone Star Funds. That's during our proceeding as well. Prior to that, that's an important proceeding, $4.5 billion. They're on opposite sides. So clearly, they are not tied at the hip. They're not an inseparable duo. They don't always work for the same interests. And this is something that they did not, that Dr. Alexandrov did not think warranted disclosure, but it certainly does not indicate any bias. The objective evidence certainly doesn't indicate that this relationship went beyond a normal working professional relationship. Guatemala's allegations regarding— yes,
I don't really understand what's in the case versus Korea, the dates that are inside the circle. Can you get— so it's December 2012. It started December 2012. Somehow the tribunal got reconstituted the way you—
Unfortunately, President Viter passed away. It was when he was ill. He resigned, and then it was reconstituted. And then they— yes, and after reconstitution, I mean, so they had never issued their award. It was still pending. When I said we have the distinction of being one of the longstanding cases, this is also one of the very longstanding cases. So it's been going on for a long time, and there has not been an award rendered.
In October 2020 was the hearing.
There was a hearing in October 2020, and that's yes, we can see that from after the tribunal was reconstituted.
And Alexandrov and Kazmarek, they've been involved since the beginning, I understand. Is that so? I mean, I don't know why we have the
yes,
the hearing.
I believe so. Yes.
Why would the hearing date be somehow relevant to us?
It just shows that not only was this case ongoing, but there was activity in the case.
Okay.
There was actually a hearing where they are on opposite sides during our resubmission proceeding, because Guatemala has made a big deal about the fact that expert reports for Peru were being filed during our hearing or during, our proceeding in close proximity. Well, the same thing was happening in the Lone Star Funds case. There was actually a hearing, so there would have been preparations for that hearing and stuff, and they are in adverse interests there.
Okay.
So then Guatemala's allegations regarding the so-called ICSID-Navigant relationship also have no bearing on Dr. Alexandrov's independence or impartiality for several reasons. First of all, they look at a slew, again, of information that's available from public sources dating back as far back as 20 years ago. So apart from the waiver issue, a 20-year-old representation, they do not even make any attempt to show how that could have resulted in a manifest lack of independence or impartiality on Dr. Alexandrov's part. Second, there are a number of unsupported allegations here, and we pointed that out in our briefs as far as they're saying that Sidley was Navigant's counselor for several years for which they have no evidence. They rely on representations that both predate and postdate either or both of Dr. Alexandrov's joining Sidley, leaving Sidley, Mr. Kazmarek's leaving Navigant, and all of these representations are in different practice areas out of different offices. You basically have Sidley's Chicago office doing some M&A transactions with or for Navigant, and there are securities class lawsuits. So for all of these reasons, it's unrelated subject matter, unrelated individuals. The timing is old. It posts or predates different things. It just cannot possibly show any manifest lack of independence or impartiality. And indeed, Guatemala has not supplied any jurisprudence in support of these allegations, any jurisprudence where a finding of a manifest lack of independence or impartiality has been made in circumstances analogous to these. And the final point that I want to make is that Guatemala also has now raised in its reply for the first time that Dr. Alexandrov made certain remarks at the hearing that show that he is manifestly lacking independence and impartiality. As you can see on slide 67, Guatemala has waived its right to bring any such claim, even apart from the other arguments we have on waiver. And that's because, as the Pezold versus Zimbabwe ad hoc committee recognized, if there is a problem that you have at the hearing, you have to bring a disqualification application either at or promptly thereafter. You don't wait several years after an award has been issued. You see that you lost, and then you complain about something that was said at the hearing. But also, when you look in context at these remarks that Guatemala complains about, they are not only innocuous, but they actually show that Dr. Alexandrov was being very thorough, was giving everyone an opportunity to answer questions, and simply did not want to repeat grounds that had been gone over the previous day. So if you look at slide 68, you will see that on March 13th of the hearing, there is a back and forth between Dr. Alexandrov and Guatemala's quantum experts, Mr. Delamer, where they are discussing the interest rate, the risk-free interest rate. The following day on the 14th, this is the comment about which Guatemala complains. Dr. Alexandrov says, we had a discussion with respondents expert about the risk-free interest rate, so I don't want to start beating the dead horse. But if you want to comment on Mr. Kazmarek's proposed rate, please go ahead. He's saying, I don't want to go over all of that again, but if you have other comments on what claimant's expert has now said, please go ahead. And this is because they had an expert conferencing session after the individual experts had testified. Similarly, on the next slide, slide 69, you see the same thing. You see that there is a discussion of how you calculate certain cash flows to the firm or cash flows to equity. And there's back and forth with Dr. Abdallah, Guatemala's quantum expert, and Dr. Alexandrov. The following day, Dr. Alexandrov says, The first issue is he's going through a number of issues. He says the first one is cash flows to the firm versus cash flows to equity. Again, that's a horse I thought was killed yesterday. Unless you have anything you want to say, I would move on to the next point, right? So he's